May it please the Court, Counsel. Prince George's County and appellants Herndon, Frankenfield, and Clark and Harding moved for reversal on 4 different counts. While I saw what the Court posted on the website with respect to the questions, we're moving for reversal in good cause. If the Court does not believe me in good cause or is not persuaded, we move that a Monell-type liability claim against the municipality is not recognized in Maryland. If the Court is still not persuaded in that argument, we would argue if you affirm the judgment, then you have to address the issue of the caps under the Local Government Tort Claims Act or 11108 of the state cap. With respect to the good cause argument, 6 days ago in the Kearney case, Judge Atkins asked on the miscellaneous docket case number 3 with respect to late filing. In this case, the Court ruled, in Kearney, the Court ruled that abuse of discretion may also be found where the ruling under consideration is clearly against logic and effects of facts and inferences before the Court. What occurred in Longtin was that, as in Kearney, that plaintiff had an attorney. In Longtin, Mr. Longtin had an attorney from the inception of his criminal proceedings. The question for municipalities, because before you can get out of the gate on lawsuits against municipalities, is whether you provide timely notice. And if you didn't provide timely notice, the question then becomes good cause. In this case, as Judge Zarnock ruled, he found that there was sufficient evidence for good cause. And when you examine the record, you have to, it's our position that he erred, so that Judge Nichols and Judge Lamazny erred in finding that the evidence on the record was sufficient for good cause.
Wasn't the respondent in jail when the clock ran on his notice?
Yes, but he is entitled to a malicious prosecution claim. When his notice ran, you're correct, he was in jail. But that, we don't have an opinion other than the opinions of Herron and subsequent opinions finding the dependency of a criminal proceeding is not sufficient for good cause. The issue must be addressed at minimum whether in Longtin, under those facts, it warrants good cause. All of the prior opinions of this Court suggest that being incarcerated and focusing your energies on the criminal proceedings is not good cause.
Now, in the other cases, were the defendants incarcerated or were they just defending themselves?
It's my understanding in the Herron, the unpublished opinion in Herron, which this Court took.
Unpublished opinion?
There was an unpublished opinion, but this Court took cert in Herron and found that you have to look at the legally operative facts of the cause of action. When did they arise? We know that Mr. Longtin professed his innocence from day one, that he did not commit the murder of his wife. We know that. We know that the false arrest would have taken.
I'm still unclear. In the other cases involving good cause and people who are defending against criminal prosecutions, has either appellate court held in a reported opinion that there is no good cause when you are incarcerated, or they just held there's no good cause when you're free and you're defending?
There's no reported opinion stating that. What we are relying on are the earmarks of good cause founded by this Court that we relied on, which was that the pendency of a criminal proceeding and focusing your energies on that case.
That alone is not enough.
Is not correct. So when, in the Kearney opinion, when the Court footnoted to the Rios earmarks of good cause, we are relying on the principle of stare decisis that we were on notice as to what good cause, the factors of good cause were at that time.
But what difference does it make what you were thinking? The issue is, did the plaintiff timely comply with the requirement, or is the plaintiff entitled to an excuse?
Well, that's exactly the question.
I mean, if you're saying we shouldn't have to pay for their brief, I mean, maybe what you understood the law to be is of some relevance to that. But
Fair
What difference does it make?
Fair enough. The major question is what you said. What did the plaintiff think?
Yeah.
The review standard is what a reasonably prudent person in his position would have done. What he did, and we know on the record, is that he retained an attorney. He had Mark Epstein, which is a stipulation in the record, that he called that person that day. We subsequently know on the record that when the notice of claim was submitted to the county, Sam Serio was CC'd on the notice and another attorney. We know that Mr. Longtin had access to attorneys, and the question becomes whether he acted as a reasonably prudent person for excusable neglect or mistake, because the other factors doesn't apply.
Well, why did the Circuit Court and the Court of Special Appeals get it wrong?
They got it wrong because Judge Zarnock relied heavily on incarceration and the fact that the DNA, he concluded, was withheld. The significance of the DNA testimony is very important because there's a published opinion that Prince George's County withheld DNA from Mr. Longtin. When you look at the record, the DNA, there are 3 different DNAs, one that came out in January, one in February, and one in June. The January DNA excluded Mr. Longtin and his wife as possible sources of the DNA found on the couch. In February, the DNA excluded Mr. Longtin as a possible donor of the vaginal swab from the decedent. The prosecution's theory of the case was, and Mr. Longtin's testimony to the detectives, was that his wife was cheating on him. Not finding Mr. Longtin's DNA as a match in the vaginal swab was consistent with him being estranged from his wife and possibly the person who murdered his wife. That is not what I believe. That is what the record developed at the time. Then you have the June DNA. When it, for the first time, the Prince George's County Police Department realized that Osby is a possible donor of the swab, and subsequently he was charged with that crime. Mr. Longtin was then released. The significance of the facts of this case is what you have to look at what Ms. Fran Longwell testified to. Fran Longwell testified that she made the decisions to keep Mr. Longtin in jail. It was not the detectives who did that. The DNA was revealed to her, and she made decisions to continue the prosecution. But still going back to what would a reasonable, prudent person would have done, Mr. Longtin retained attorneys for his criminal proceedings, but did not do so for the purposes.
So a reasonable person sitting in jail waiting trial for murder would have to put the county on notice of his intent to assert an action for which he would be compensated before the trial of the criminal case.
Under the notice provisions of the Local Government Tort Claims Act and the Court's prior opinions that we're relying on, we believe yes. If the Court disagrees with me on the good cause, we then go into the issue.
Why wouldn't that be good cause to extend the time to put the county on notice?
Because being incarcerated you have to go back to Heron when the Court made a decision as to when does the legally operative facts come into play and when do they exist. The Court has ruled that a seizure occurs from the time you take somebody into custody. If certain offenses are established from the date of arrest, you cannot then find good cause because this person later found out the DNA evidence. Remember, Mr. Longtin waited 4.5 months after he received the DNA, after he was released in June. So then, to examine your question, why isn't it good cause, he waited 4 months after the June DNA. So are you saying that if you take your position that you cannot measure somebody's reasonable conduct because they're incarcerated, then at any time somebody decides that, well, I feel like I couldn't retain counsel or I didn't think about it then, therefore that's good cause. The opinions of this Court suggest otherwise. In the Kearney opinion, that person had an attorney. Mr. Longtin had an attorney. And why you would have to either decide the issue as to whether being incarcerated is a reason for good cause to waive the notice.
Well, it's something to be weighed in the process. What's the standard? It's an abuse of discretion standard.
It's an abuse of discretion standard, but it's
Why
not.
is this so far removed from what a reasonable person would do so as to require us to reverse it, applying the abuse of discretion standard?
I think when you look at the facts and the reasonable inferences to be drawn, given that Mr. Longtin had, at least we know, 2 attorneys immediately, Mark Epstein and Sam Serio. Subsequently, he retained other attorneys that placed the county on notice and copied another attorney. I think the access to counsel, the fact that he had counsel in a criminal case, goes to the factors that you weigh whether this person, Mr. Longtin, did not act as a reasonably prudent person. But my recommendation would be that based on the case law that's developed, it is not good cause to waive notice, especially under the circumstances of the Longtin case, because he had an attorney. Now, if you disagree with me on the notice issue, we move to the issue of the Monell claim. And we have briefed the Monell claim adequately, and I've had the support of amicus that talks about whether you should recognize a state Monell claim. I think that in this case, we were put in a position to defend a federal claim without the benefits of the federal defenses. Because in a Monell claim, you have to find that the individual officer committed a constitutional violation before you can trigger the issue of Monell liability. I believe, and I've cited in the brief.
Excuse me, just moving back to the notice for a minute or two. He was found, he was notified that the DNA did not match and that there was this other person, Mr. Antonio Oglesby, whose DNA did match. What, on the day he was released from prison?
The record shows that when he, on June 11th, he was released on the following day, I believe the 12th.
June 13th.
June 13th, correct. Right. So,
okay,
but,
so is that the point? When do you think his cause of action accrued?
His cause of action for malicious prosecution accrued on when he was released, and this Court has said that the only cause of action where the legally operative facts will start is on the malicious prosecution. We don't dispute that.
Now, was he notified on June 13th, 2000?
I believe the 12th. And what occurred was Ms. Longwell moved the following day on a motion to release him. And she said, even though I'm releasing him, I believe that I will still continue with the prosecution of my case. And this takes us back into where does the liability suffer? If a prosecutor makes an independent determination to continue seizure, are the officers liable for that continued detention? And we made that argument with respect to the notice, and this is why I think, Your Honor, that the issue of a reasonably prudent person standard is important, because the officers cannot be held liable if the prosecutor, notwithstanding DNA, says, I am going to continue the prosecution. How can you find liability on the officers for the continued detention? And that's why I believe the issue of good cause is an important one, because if the case is not reversed to be tried on the issue of malicious prosecution, we cannot really adequately defend the continuing seizure of Mr. Longtin. So I would submit to the Court that the ripe action that accrued was malicious prosecution, which we are not disputing notice was timely on. Going back to the Monell claim, I cited extensively Richard versus Donnelly because the issue here is whether or not this Court should recognize the federal claim of Monell state liability against Prince George's County. We submit that the Court should not recognize it for the reasons being that respondent superior liability is available to a plaintiff against Prince George's County. And if you recognize the Monell-type liability that was prosecuted in this case, you're really taking away from Prince George's County defendants what the federal courts intended, which was qualified or good faith immunity. Because if you allow this claim to stand, you are depriving the individual defendants from making the argument that they are entitled to qualified immunity or good faith immunity as is recognized in the federal courts. Now, why we know that this claim should be rejected is because this court has held repeatedly that there is no immunity for a state constitutional violation and that there is respondent superior liability against the county. So this Monell-type liability state claim has allowed the sideshows of municipal liability to come into evidence against the individual defendants who could not defend against it on qualified or good faith immunity. The other question then leads into, if you recognize this claim, what is the actual cap on damages in Prince George's County or in the state of Maryland? The issue that is being raised by Mr. Longtin is that, and Judge Zarnock, is at the time of this incident, the Local Government Tort Claims Act did not apply to Prince George's County because of the Housing Bennett decision and Dua versus Comcast. We now know 47 days ago, in the majority opinion of St. Mary's County versus Marcus, that the court said that Chapter 286 was clarifying legislation of what the legislative intent was under the Local Government Tort Claims Act. Unless I'm misreading Marcus, it seems to me that what the court is saying, that 286 does not divest you of a cause of action or a right that you had. Amicus has briefed this issue as well as we have, and what we are saying is that Mr. Longtin was not any cause of action that he had in 1999 was not taken away because of 286. And here's how we know that. Let's assume for a moment there was no such thing as a Local Government Tort Claims Act. There is 11108, which is the Maryland cap on damages for non-economic damages. When Mr. Longtin recovered his money, he was subject to 11108, whether there was a Local Government Tort Claims Act or not. The fact that the Local Government Tort Claims Act in 1987 said that you are capped as to the recovery you can get against Prince George's County, and the 286 was just clarifying legislation of what the legislative intent was, it is not taking away a cause of action. He still pressed his causes of action. All we are saying is that 286 limits his recovery against Prince George's County, Maryland. Now, that leads us into the issue of how much money can he recover based on the judgments in this case. And then you have to look at the record, and there are 5 judgments in this case. One against Prince George's County, Maryland for $5.2 million, which was reduced to $5.02 million. 1 and 4 different judgments against the individual officers. Mr. Longtin never challenged the judgments, never moved to amend or modify the judgments in this case. The $5 million and change is against Prince George's County. Then you have the 4 separate punitive damages award. The significance of this, and I believe for the court to resolve, is when you look at the causes of actions, the intentional torts were determined on a preponderance of the evidence standard, and the award of damages came down at $5 million and change. The jury was then instructed separately, you can award punitive damages, and they awarded punitive damages. Judge Nichols vacated 3 of the judgments and reduced 1 to $50,000. Under the Local Government Tort Claims Act, you can only execute a judgment against the employee if it was committed with actual malice. The judgments in this case that are against the employee are the 4 separate judgments. 3 are nullity right now. It was never cross-petitioned. And the 1 for $50,000 is what you can execute against that employee. With respect to the $5 million and change, it was against Prince George's County. We are now making the argument, which we believe the court erred in its interpretation of DUA and 286, that there was ample authority that the cap on damages was $200,000. If you disagree with me that the Local Government Tort Claims Act doesn't cap the county at the if you agree with me that it caps the county at $200,000, and then you say, well, what about the excess? The question then becomes, upon execution of that judgment, what is the cap? And this court recently ruled In Green versus NBS in 2009, and subsequently affirmed, I believe more recently in DRP Pool Services, affirming the cap on statutory and constitutional damages. So, for example, you disagree with me, you agree with me that the county's capped at 200, and you say, what about the rest of this millions of dollars that are out there? Mr. Longtin damages are capped under 11108 because Prince George's County, under the Local Government Tort Claims Act, can, pursuant to 5303E, can assert any defenses that an employee may have. So upon judgment presentation, they said, well, we want this extra money. If the court rules that you're capped at 200, we believe we can execute this against the employee. And the employee says, well, wait a minute. I have a defense to a judgment in excess of, at the time of this incident, would have been $575, and you add, I believe, the $15,000 or $10,000 for the other years and interest. But we can assert 11108. Amicus talked about 11108 and the county abandoning this argument. We don't believe that it's an abandonment of the issue. It's a jurisdictional issue. And here's why. When the judgment was entered in this case, we appealed. There are judgments of $5.2 million and four other judgments, but one that really stands. So when the time to collect the judgment occurs, we can say we have a defense to the amount of the judgment that you can recover from Prince George's County, for example, 11108. Our argument to the court is to decide the issue. If you decide on the Local Government Tort Claims Act that the county is capped, and you disagree with me that the excess can be recovered against the employee, as the plaintiffs are arguing, then you have to decide, isn't this money capped under substantive law in Maryland? And when you look at the Green versus NBS case, when we argued 11108, we had Cole versus Sullivan. And in all fairness to counsel below that argued Cole versus Sullivan, it said it didn't apply to intentional tort. So we followed what the law was at the time. Subsequent development, and I think it was an error of the trial court and the appellate court to rule that 11108 was not applicable. Because, and again, I'm pressing that the issue is not abandonment. The issue is jurisdictional. Because if you affirm the judgments in this case, and the plaintiffs then come to Prince George's County and say, hey, we said we are only paying what the cap allows us, and it becomes a motion to enforce a judgment, we can then cite to the substantive law in Maryland that caps us at $575. So my argument to the court is that first you should rule, pursuant to Marcus, that regardless of your theories of liability against Prince George's County and its employees, that your cap is 200. One of the significant issues here with the record is that the plaintiff conceded, and in fact there was a stipulation on the record, that the acts or omissions committed by the employees were committed within their scope. And we know that the Local Government Tort Claims Act says that if actions, tortious acts or omissions are committed within the scope, you cannot execute against that employee. Then you have the second provision of the Local Government Tort Claims Act that says that the employee shall be fully liable if there's actual malice. Now, I attached an unpublished opinion to the court that Judge Murphy wrote when he was in Court of Special Appeals, and the issue there was the Local Government Tort Claims cap. He agreed that it applied, and he talked about 286, and that's why I put that in the record, because we really didn't have much guidance with respect to the Tort Claims Act. I part company with the court when he said that the other employee was fully liable for the judgment, for all of the judgment. He might have been right that that employee might be liable if there was actual malice, not malice. Because
well, in that case, and I don't know the extent to which it's precedent or it's persuasive authority, since it was an unreported opinion, but in that case, a lot of arguments were made on appeal that essentially not only had not been preserved for appellate review, but were directly opposite to the arguments being made at trial. The issue of malice being one. There was a concession that if the jury made a specific factual finding, that conduct had been engaged in with malice.
Correct.
So I don't know that that advances the ball very much.
But here's why the Court should give consideration to this record. The common malice that you see after the findings of each count is superfluous language because the Court instructed the jury that an officer cannot be liable unless that person commits malice. So you couldn't even reach the question of liability if you didn't think that they for instance, malicious prosecution. My time is up. Malicious prosecution, an element, is malice. But actual malice is what you need in order to enforce a judgment against that employee.
Thank you, sir.
Thank you.
Mr. Hansel.
Thank you, Your Honor. Good afternoon, and may it please the Court. My name is Cary Hansel. It's my great honor to stand here today and represent Mr. Keith Longtin. I want to start at the beginning with the notice issue. It's not properly before this Court. The simple reason is because it was only raised by way of a motion for summary judgment. That motion for summary judgment was denied, and it was never again raised by the defense at any stage during the pretrial, during the trial, or in the post-trial proceedings until we came for this appeal. As a result, it's simply waived. The Court held in Ditto v. Stoneberger, the denial of a motion for summary judgment cannot be the basis for a successful appeal. This Court held in Three Garden Village Partnership in 1989 that even if the record before the circuit court at the time of the motion would have supported summary judgment, the trial court's discretion to deny or defer ruling ordinarily prevents an appellate court from directing that summary judgment be granted. Simply put, in 234 years of Maryland jurisprudence, there is not a single case that was not later overturned or abandoned by the court in which the denial of a pretrial motion for summary judgment was overturned on appeal. It has never happened, and this Court will be throwing open the doors to something it has never done before and which it has explicitly disallowed, even to consider the notice argument. So it isn't before this Court, and this Court is not alone in that regard. Courts all over the country have so held, including in federal court, the Fourth Circuit. The Court of Special Appeals recently cited the Fourth Circuit in the Basilico case to the effect that the Court will not review at all, will not review under any standard the pretrial denial of a motion for summary judgment. So this entire question of notice, only raised in a pretrial motion for summary judgment which was denied, is not properly before the Court and was simply not preserved because it was never again raised until post-trial, and that is not sufficient under the entire history of this Court's precedent, including the federal courts which Basilico incorporated into Maryland law. And it's important to realize, as the Court in Basilico did, that to overturn the denial of a motion for summary judgment would be, quote, nothing short of substituting a known unjust result for a known just one. And that, in essence, is what the county asked the Court to do. Sweeping that aside for the moment and focusing on the merits of the county's argument, which this Court ought not reach very respectfully for those reasons.
Would we have to reach it if it was styled motion to dismiss?
I don't think so, Your Honor. I think that if it's raised pretrial, even if it's styled motion to dismiss, the Court went on to treat it as a motion for summary judgment, and the reason was because it relied on issues that were extra record issues. And it had to, because after all, they were making claims about when notice was given, under what circumstances, whether it was timely. These things were not in the complaint or in the pleadings. So as the Court is well aware, under the Maryland rules, even if we style it as a motion to dismiss, but if we rely, as they did in this case, on matters outside of the pleadings, it's treated as a motion for summary judgment. And when we get to the end of the day, the denial is the denial of a pretrial motion for summary judgment. I think what Your Honor points out would be the county's best argument had they made it, but they didn't. Setting that aside for the moment, I think it fails by simple operation of the Maryland rules. The trial court and every court since has recognized what we had here was the denial of a motion for summary judgment.
Yeah, they probably thought it has to go by way of motion for summary judgment because we're going to be introducing facts.
That's exactly right.
Turn into one anyway.
That's exactly right, Your Honor, and not the least of which is when notice was given, under what circumstances, so on and so forth. As it progressed, in reality in this case, that is exactly what happened. Both sides introduced facts with respect to the question of notice. So I don't believe that issue is properly before this Court, and this Court ought not countenance it or the overturning of centuries of law. Setting that aside for the moment, and even if the Court is willing to turn its back on this river of precedent that runs in the opposite direction from this Court, from other state courts, from the federal courts, and consider the issue, we have here an overwhelming case for good cause. There's never been an argument by the county, and this can't be stressed enough, that there was any prejudice at all, nor could there be, because after all, they had the entire force of the state to investigate everything that happened here. The record of their investigation of what happened is as long as your arm. I see some of the Court actually has the stacks in front of them. These are all of the documents and materials that track the movements of every officer who was involved, exactly what happened to Mr. Longtin at every point. So there couldn't possibly be any prejudice to the county, and they haven't argued any. So we come now to the issue of good cause for a waiver of this notice requirement. And I submit to the Court that there is good cause in this case. Mr. Longtin was incarcerated wrongly at the hands of the defense for the entire notice period. Information was withheld from him, and Your Honor had an excellent question. When did he learn about the DNA? He's released on June 13th of the year 2000. We learned about the DNA evidence that officers knew 4 months before they did anything to release him during the pendency of the lawsuit years later. He didn't know about it then. It wasn't disclosed to him then. It was not even disclosed to his criminal lawyer as Brady material, which would be an absolute constitutional requirement. So
what did he know about why he was released?
He knew on June 13th that they were charging someone else and that the other person's DNA had been positive. And that happened approximately 2 weeks before he was released. So he's held in jail for 2 weeks while they know a serial rapist committed the crime and not him. What he did not know, and what was hidden from him, and what was not disclosed as required by the Constitution under Brady, is that for 4 months he was kept in jail for a crime that was known to a scientific certainty he did not commit.
Well, the question is, when did they learn to a scientific certainty that he didn't commit it?
It's in the record extract, Your Honor, at page 168. Mr. Longtin was excluded as being the possible donor of the DNA extracted from the victim's vaginal swabs.
Yeah. What was the date of that?
Oh, my apologies, Your Honor. Yes.
Something in June.
It was February of 2000. He was not released until June.
Well,
prior to that,
there were, as I understand it, there were some DNA tests
yes, Your Honor,
that wouldn't really require or compel the conclusion that he didn't do it, given the information that they had. And it wasn't until the final one that identified, I guess, Osby was back.
That's correct, Your Honor.
With the detectives that they realized we've got the wrong guy.
And
so how soon after?
2 weeks. They waited 2 weeks to release him.
He stayed in jail for 2 weeks after they found that out.
Correct.
Okay.
And they never disclosed under Brady, which would have certainly been exculpatory at the very least, that they knew for 4 months he did not match the DNA from the vaginal swabs.
It's a good cause. I understand that that's a merits argument, but
yes.
Is the good cause that he was in jail? Is that the good cause?
Let me state it very explicitly. There are 2 grounds for good cause. One of them has a couple of elements, and I appreciate the Court's patience. The first one, with the couple of elements, is he's in jail. He's in jail as a result of the wrongdoing of these officers. They were held to have lied to keep him in jail. Their own expert testified at trial that what they said to keep this man in jail was a misrepresentation and inaccurate, the words of their own expert. So here they are, they lie to keep a man in jail.
They lied to keep him there or to put him there?
Both. Absolutely both, because they lied first in the statement of probable cause. They lie again in multiple court hearings while he's in jail to determine if there is probable cause to hold him over, and so on and so forth. Also in a suppression hearing. Those are things that keep the man in jail. In addition, Your Honor, so he's in jail unlawfully. They lie to keep him in jail. They conceal facts associated with his claim. The officers in this case didn't tell anyone about the DNA excluding him from being the donor from the vaginal swabs for months. So they're excluding evidence, denying him the right to get out of jail. What does that do? It causes Mr. Longtin not to be able to investigate his claim. He can't talk to witnesses. He can't freely move about.
Because he's in jail.
Absolutely.
Okay. I'm just trying to pin down. I understand all of these things go to why he has a claim. But the implications of it are that does someone have the same good cause if they've been charged but released?
Let me explain it very carefully. I think it's a case-by-case analysis.
I know, but for the purposes of this, if we're going to say jail is the dispositive aspect.
That's not what I'm asking the Court to do. I'm asking the Court to say, we look at the facts and circumstances. To say, as the Court has said before, that the legislature trusted to the discretion of the trial judge to look at the entire picture here and determine is there good cause. There is no single test for good cause. I don't ask the Court to draw a bright line at jail, or a bright line at concealment of the charges, or a bright line that they lied to keep him there, or a bright line that they withheld the DNA evidence, or a bright line that he's unable to move about and investigate his claim to, after all, gather the information he would need to give notice. I don't even ask this Court, and I think Judge Murphy's question really hit the nail on the head. Consider this. To give notice, as a man in jail facing a double life sentence, he has to describe the events and what happened in violation of his Fifth Amendment right against self-incrimination. I think this Court could easily say, we do not find it reasonable that a reasonable person in jail, faced with the advice any lawyer would give a man who faces a double life sentence, should be called upon to preserve his rights to seek constitutional redress to violate his Fifth Amendment right.
Well, of course, one of the issues involved the interrogation.
That's exactly right.
Which occurred shortly after he was taken into custody, and I guess ended some hours later with the presentation to the commissioner. So he would clearly know, I suppose, of that violation sitting in jail. He might not know about some of the other stuff.
He would be aware of it. But would a reasonable person with a Fifth Amendment right not to say anything, facing double life sentences against officers he knows have lied to put him where he is and keep him there, want to go on record with his version of events and prejudice his defense to double life charges?
Well, that's a good argument, but is
for a
that
theoretical
the finding
claim
that the circuit court made?
I don't think it has to be, because the
Did
circuit
she make
court.
any findings on as to good cause?
The circuit court was.
I think it was.
She was very nebulous. She said, I think based on all the circumstances, there's good cause. There's good cause here. This Court has held, when that is the finding below, that it will search the record for any good cause, and that's what I ask you to do. In that regard, I want to get back to my second answer to Judge Battaglia's question. The first answer is, given all of the facts and circumstances and everything that happened in the man's Fifth Amendment right against self-incrimination, he ought not be called upon here to give notice while he's in jail, falsely accused. Setting that aside for the moment, every court that has looked at the question, and we've cited New Jersey, Washington, California, Illinois, has said that good cause will be found where public policy requires it, where the courts of that state ought to pass upon the misconduct that occurred. There will be a waiver based on public policy. We cited Hill versus Middleton, quote, even if there is no substantial requirement with the notice provision of the Tort Claims Act, a public entity will be stopped from asserting this defense where the interests of justice, morality, fairness dictate that course.
Well, and this Court has issued some sovereign immunity notice cases that were pretty harsh with respect to denying the claimant's right to sue.
While always recognizing that the ultimate discretion rests with the trial court and that it is an abuse of discretion standard, and while also saying in the Moore case that the standard is meant to allow the court to achieve substantial justice under varying circumstances. And so you're absolutely correct, Your Honor, but to achieve substantial justice under varying circumstances, the court should consider that in this case, these officers testified they were trained to use sleep deprivation. 55 years earlier, in the case of Ashcraft versus Tennessee, the Supreme Court said that is an unconstitutional form of torture. Yet 55 years later.
Are we going to be making up these are we going to be finding these things? Did the trial court find these things in support? Because the bottom line is, if the trial court found it, then we could say these findings support good cause. But you've indicated that the trial court made no findings, just said sufficiency, and we can certainly identify it, but now you're asking us to make the findings on the record.
I respectfully suggest two things. First, what the trial court said was based on the entire record. So what I'm offering you is what that record was before the trial court. So the trial court's, and it comes down to not a bright line test, but this varying circumstances and doing justice in varying circumstances, which is what this court said the good cause standard is requires of it.
Rios, what Judge Atkins is referring to, Rios, we did not find good cause. And that was pretty harsh.
I agree with that.
I mean, that's the bottom line.
I agree with that. But it didn't rise to the level of what we have here. This is one of the grossest cases of police misconduct, probably in the history of this state, if not the country. We have officers trained to use sleep deprivation. We have them trained to violate Miranda warnings, and intentionally so. They're told, when you do this, according to the written training that our department has authorized, it will be suppressed.
Are there any cases which tie the good cause to the nature of the cause of action? In other words, is his claim for good cause better because they did all these atrocious things?
Absolutely. Absolutely. And every court in the country to consider it has adopted public policy grounds as a manner of finding good cause.
So it varies with how trivial or how severe your claim is?
I think it may under a public policy analysis.
That's a kind of a really slippery slope.
Not according to New York, New Jersey, California, Washington.
Why do you counsel us not to adopt a bright line rule of tolling while incarcerated?
I think you could. Okay, I don't counsel you not to. However, I think the standard that is in the statute is actually looser than that. So the court could find a bright line rule that says there's tolling for incarceration, or the court could find a bright line rule there's tolling during incarceration if it's wrongful at the hands of the defendants, you know, et cetera, et cetera.
You could apply a discovery rule to it as well.
I think that would be a reasonable conclusion that this court could reach. Setting all of that aside for the moment, the fact that it wasn't preserved, public policy, the question of incarceration in this case. Oh, before I leave, though, I want to mention Herron versus Strader, because the question was asked, and counsel cited Herron versus Strader as the case that stands purportedly for the proposition related to incarceration. In Herron versus Strader, the plaintiff was incarcerated for 2 of the 180 days of the notice period, 2 days. And there was no testimony whatsoever that the incarceration was wrongful at the hand of the defendants in that case.
My recollection is this court has held that jail alone is not enough. I'm sorry, that defending is not enough.
That's true. That asserting, that helping in your defense is not enough. And Herron versus Strader stands for that proposition.
And has not addressed jail?
The question of jail came up in a case called White. But in White, the person was justifiably jailed. And I don't have the full cite in front of me, but I'm sure it's in my papers, Your Honor. In White, somebody was justifiably jailed, and the rest of the circumstances, I don't think, were what this court has in front of it. Didn't come anywhere near that.
Doesn't that make your Fifth Amendment argument somewhat less weighty? Because a defendant, whether he or she is in or out of jail, that right is similarly implicated if they're hoisted on the horns of a dilemma of whether to violate their Fifth Amendment or give away their Fifth Amendment privilege.
I think the Fifth Amendment privilege issue applies either way, whether you're in or out of jail if you're facing charges, okay? So, again, I didn't say the court ought to adopt a bright-line rule at incarceration. It may, and that may weaken, if it did, the Fifth Amendment argument, but I think both are strong, and the court could find any one of a number of avenues past the notice issue here. Avenue 1, it's not preserved. Avenue 2 is the avenue taken by the trial court.
I think the only reason, at least I was, and maybe others, were getting into this line of inquiry is that you were trying to channel us in one direction, and there seemed to be multiple ways to get where you want to go.
There are.
And you were shying away from those.
No.
And I wanted to know why.
Not in the least, Your Honor. In fact, I would suggest to the court that there are multiple avenues here available.
Okay.
Say no more. Okay.
Well,
Understood.
Well, I do know you want to move on, but before you do, What is your response to what I believe I understood opposing counsel to say, albeit it came up sort of in the DNA and who knew what when and so on, that it was the state's attorney's decision to continue to prosecute this case up to a point, and really not the police decision? So,
two things.
Yes,
the first is that has nothing to do with any issue raised on appeal. Notice the cap, pattern, and practice.
I think he was. Well, counsel will correct me, but yeah. I gathered that he was trying to cabin it into somehow, there's the good cause. I don't know. Maybe not.
I see no relationship to that argument in any issue on appeal, number one. Number two, that was not the case, is not the case now, and we've never asserted any wrongdoing on behalf of the state's attorney. Instead, what we have said, correctly so based on this record, is that the officers failed to disclose information in a timely fashion to the prosecutor, so under Brady, it could be disclosed to the plaintiff. And that didn't happen in this case. But that is a very small, minute part of the liability in this case. The overwhelming issue is you can't keep a man up for 39 hours with relays of officers and subject him to what the Supreme Court called torture in a case that involved 3 fewer hours of interrogation. You can't deny him a lawyer when he asks for one. You cannot lie to put and keep a man in jail. That's our case. Now, moving on to the question of pattern and practice. Counsel views it as a Monell claim. Simply put, it is not. It is nothing more and nothing less than what this Court recognized 15 years ago in Ashton versus Brown, which involved an illegal, unconstitutional policy adopted by the city of Frederick involving a juvenile curfew. This Court has said for the entire period since then that you are entitled in a separate cause of action to challenge unconstitutional policies of a local government. There is really nothing striking or new or unusual about the count pleaded as pattern and practice in this case. It is simply that. It is simply a challenge to an unconstitutional policy. If this Court, as the American Civil Liberties Union pointed out as amicus, were to decide otherwise, it would be overturning decades, if not centuries, of case law and turning its back on every potential violation of the Constitution that finds itself into a policy as opposed to an affirmative act in a particular case. So there's nothing new or unique about the pattern and practice claim before this Court. It is not a Section 1983 claim. It is not a Monell claim. It's simply been misunderstood and mischaracterized by the defense. If the Court feels that it nevertheless needs to adopt something new in order to recognize this claim, we would urge that the Court do so. We would urge that the Court, in cases like this, review the patterns and practices of local governments. When those pattern and practices include written instructions to violate people's rights, include training on unconstitutional practices, include falsification of charges against citizens of our state and our country. When that is the case, we would urge that this cause of action be adopted if it needs to be, but our position in the first instance is that the Court needn't adopt anything or change one iota of law. I would point out that this is critically necessary to be able to assert these claims in a state court in Maryland, because our state constitutional rights in many, many instances are broader than those granted by the federal Constitution. This Court has held, for instance, that under Article 22, we have greater rights against self-incrimination than under the Fifth Amendment, that under Article 24, we have greater rights as relates to equal protection than under the 14th Amendment, that in Article 25, we have greater rights than under the 8th Amendment as regards to cruel or unusual punishment in the language of our Constitution, that under Article 7, we have greater rights to political participation. So it is critical that this Court review, under its own Constitution, patterns and practices of unlawful misconduct, and we would urge the Court continue to do so, not adopt a new cause of action, which is not required. The next question counsel raises is the question of the cap. Again, the cap can be very simply addressed. In this case, there were 18 findings of malice, which was defined by evil or rancorous motive influenced by hate, the purpose of which is to deliberately and willfully injure another, to commit extreme and outrageous misconduct in a manner that would be highly offensive to a reasonable person, intentionally and in a manner shocking to the conscience. The jury, in this case, after a trial that lasted many weeks, found 18 times that that standard was met.
Well, how does that play out, though, with respect to the claim against the county?
Very simply in this way, Your Honor. Under the statute, malice provides that the claims against the officers are uncapped. The county has agreed to indemnify the officers. So for all practical purposes, despite some very interesting esoteric issues about how we can wend our way through the cap issue, for all practical purposes, the finding of malice really ends the inquiry.
So if we said the cap is applicable to the claims against the county, it wouldn't implicate your right to recover because of the indemnification features of the relationship between the officers and the county?
Not in our view, but I think it would have disastrous effects for every case to follow. And for that reason, it's important that we defend the argument that's made by counsel, even though in this case it may well be moot. And part of the defense to that argument is the Bennett case. The Bennett case held that constitutional claims are uncapped. As the Court is well aware, there was a legislative attempt to change Bennett, to legislatively overrule this Court's findings. But the question is whether that applies retroactively. It's a two-part test. Part one is intent of the legislature. And this is a critical point. The legislature said that statute would apply to cases, quote, pending on the effective date of this act. Pending on the effective date of this act. Literally interpreted, it doesn't apply to anything that hadn't been filed on that date. This Court has held that it will strictly construe the legislature's intent to avoid retroactive application. So that statement is at the very best ambiguous. I would suggest it's not ambiguous, and it clearly says only if it's pending on that date will the...
It doesn't apply to any other case except cases that are pending on that date.
I didn't write it, Your Honor. You ought to hold the legislature to its words. And this Court has said that it will strictly construe...
Interesting argument. Maybe we can so hold.
This Court has said...
Why do you argue that instead of arguing or ahead of arguing the vested rights?
Well, that's the better argument. Okay? So
Which
let's
is?
the vested argument.
Okay.
The vested rights argument. So let's get to it.
That's what I thought.
And here is the question. This statute cannot be constitutionally applied retroactively, even if that's what the legislature meant, Your Honor, because it interferes with vested rights. This Court held in Dua that a vested right vests in something as simple and minute as a demand.
Right.
This Court held in Dua that a vested right includes a cause of action. This Court held in WSSC versus Riverdale to the same effect. In addition, in Allstate versus Kim, this Court held that the retroactive grant of government immunity could tread upon a vested right. The retroactive grant of government immunity could tread upon a vested right. That is exactly what we have in this case. This is the retroactive grant of governmental immunity for anything over $200,000. It is no...
But it really doesn't matter, as I understand it, because the individual officers will be indemnified.
Here's why I think it matters. I think the county may well, and has already, suggested that when we come to collect this claim, they will make every conceivable argument that they believe they have on behalf of the officers. This will be one of them, and I think this Court ought to decide it now, because otherwise we will be back here on this question.
Well, there may be a pretty serious conflict between the interest of the county and the interest of the officers if they're going to try that.
And they were all represented by the same counsel at trial, which is why the county has to and must, to avoid putting their counsel in a horrible position of conflict, indemnify the officers. I have information to the effect that they do not intend to do that, Your Honor, and so I think the Court ought to reach all of these other questions, including whether or not the cap is constitutional for the same reasons that we have argued that the notice period itself is also unconstitutional.
Have any of the cases along the DUA line dealing with vested rights dealt with rights where the cause of action was not abrogated totally but was limited in damages?
The answer, I think, is no. However,
how about other states?
In other states, I think the answer is no. However, if we read the logic behind all the cases in Maryland, the logic would be that to cut somebody off at $200,000 in a case that's worth $6 million clearly, retroactively abrogates their cause of action. Mr. Longtin, when this case started, had an asset, something as simple, again, as a demand or a cause of action, had a vested right in it. The value of that asset, we now know, was somewhere approaching $6 million.
I'm just wondering, though, if you look at law regarding vested rights, whether you're going to run across a problem dealing with curtailment but not denial of those rights.
I don't think there's a difference, Your Honor. Curtailment is denial. You know, it goes back to the power to tax is the power to destroy.
Diminish rather than
But then where would the court draw the line? If we can diminish your rights from $6 million to $200,000 and you haven't lost $5.8 million you had a vested right in, then can we diminish it to $1? Can we diminish it to 50 cents? Can we diminish it to zero? I don't think that distinction can reasonably be made by any court. I think instead what we have to look at is, has he lost something? And he's lost more than $5 million if the court applies Bennett retroactively. And as a result, we very respectfully suggest it ought not. I thank the court for addressing these very important issues, and I ask that the opinions below be affirmed.
Thank you, sir.
Thank you.
Mr. Kumar.
Thank you. Yeah, let me start from where plaintiff's counsel left off with respect to the damages. If you look at the record extract E783, where you have the compensatory damages, the non-economic damage award is $5 million. That's the non-economic damage award. That's what he's talking about with respect to is that being taken away. Whether or not you agree with us on the cap, you have to agree with the substantive law in Maryland under 11108. No right was taken away from Mr. Longtin. He filed his lawsuit after 286 was enacted in October.
Well, but it had accrued before that.
It had accrued, but his causes of actions were not taken away by 286. The limit of recovery was addressed by 286.
They were curtailed.
Which according to the legislative intent and St. Mary's County versus Marcus was clarifying legislation of what they meant in 87.
What difference does that make? I mean, because what they did, you can call it clarification, call it whatever you want, but in the interim, the law had changed by virtue of the decision of this court.
What law?
And then the legislature said, well, that's not what we intended. But that did not have the effect of reinstating the law beyond the point where they clarified it.
Everything that Mr. Longtin was entitled to was pressed in his complaint in October. Nothing was taken away. What 286 is addressing is a limit of liability. If you disagree with me on 286, you cannot disagree with me in 11108.
I can.
How?
Just did.
No. But how does How does 11108 not cap the damages in this case as to non-economic damages?
I can't go back through it.
Fair enough. But my argument is that the non-economic damage award and the law in Maryland is that is capped at the time of this incident is 575. So
I'm sorry, say that again?
The law in Maryland at the time that his actions accrued and what he was entitled to was $575 as to non-economic damages. That's all I'm talking about here, because the $5 million is the non-economic damages. In Maryland, you have a cap on that claim of damages, and this court in Green versus NBS has ruled that it applies, and one, it's constitutional, two, that it applies to both intentional torts and constitutional torts. So my argument earlier was that even if the court disagrees with us on the legislative intent of 286, the issue that we believe, and I agree with plaintiff's counsel, that must be addressed to at least resolve the issue of this litigation is that what occurs if the court disagrees with us on 286, what is he entitled to recover? And my argument to you, as amicus properly noted, that his damages as to non-economic damages, not the punitives, not the other damages, as to the non-economic damages in Maryland is capped.
But they weren't capped. Well, maybe I'm wrong about that.
No, they were capped.
They capped at the time of the accrual of his cause of action?
Correct. Forget the Tort Claims Act altogether. If you just look at this action as a non-economic damage action.
So that's a question of whether the common law violation of constitutional rights under common law claim is subject to the cap.
Correct. And when you look at Green versus NBS and you look at some of the opinions that came out that deals with the constitutionality of the 11108, this Court has made it quite clear that it doesn't deny you access to courts. It doesn't deny you a claim. It is a limit of liability that substantive law in Maryland says that it is non-economic damages. And that's where the $5 million, when you look at the record, that's where the $5 million comes into play. And it's a very specific, very important argument because that is capped. Regardless of the Local Government Tort Claims Act, regardless of 286, we are still back at, if Mr. Longtin comes to execute his judgment under 5303E, Prince George's County, to address the Court's question of conflict, we have to indemnify. And we'll say, okay, we're going to indemnify up to the substantive law in Maryland, which is 11108. That is a defense that we can raise pursuant to the Local Government Tort Claims Act on behalf of the employee. That's his defense to an excess judgment that 11108 permits him to get.
Well, that creates a little bit of a problem because we're dealing here with specific findings of malicious conduct.
And the Court has addressed intentional and state torts as being capped in Green versus NBS. My position is that the non-economic damages are capped. The punitive damages, a finding of actual malice was found in this case, which can be enforceable against the one employee. But the non-economic damages are capped even if you can enforce it against him or her.
Thank you.